In a medical malpractice trial in New York, is it acceptable, is it possible for me to ask the doctor whom you have sued at trial when I'm cross-examining him whether he committed malpractice on my client or his patient? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney, and the answer is yes, it is. Not only is it acceptable, it's something that I have to do. But I will tell you something. If you find an attorney who comes right out and asks the doctor, "Hey, doctor, did you commit medical malpractice on my client?" That is the worst type of question you can ever ask. What's the only response the doctor can answer? Of course not. I did no such thing. The doctor's going to deny it and then get very defensive. So that is not the way to approach that question. Instead, there are different ways to do it. The first way is to establish what is the standard of care for this particular problem. Doctor, would you agree that when a patient comes into you with the specific complaints I'm going to tell you about, it's appropriate to take a thorough history? Yes? Okay. Would you also agree it's appropriate to record that history in your notes? True? Yes. Doctor, would you agree that a patient who presents with the following problems, the appropriate standard of care is to do A, B, and C? And now once he tells me yes, now I can go further. Doctor, would you agree that there are many different possible diagnoses for a patient who presents with those symptoms? Yes, I would. And in order to evaluate exactly or try and diagnose what the patient has, would you agree it's important to create what's known as a differential diagnosis? Yes, I would. And a differential diagnosis is nothing more than a list of the most likely cause all the way down to the least likely cause. Isn't that true? Yes. And would you agree, doctor, that in order to rule in or to rule out whether the patient has the most likely cause, you have to perform various diagnostic and clinical tests? Isn't that true? Yes. And if you find that your testing did not reveal the patient had the most likely cause, now you go to the next possible cause. Isn't that true? Yes. And you have to perform certain diagnostic and clinical tests to either rule in or rule out that particular condition. Isn't that true? Yes. So now what am I doing here? I'm establishing the standard of care for a patient who presents with these problems. So now when I'm cross-examining the doctor at trial, not only will I have him establish in his own words what the standard of care was for this particular problem, I'm going to show to the jury what exactly the doctor did, and then I'm going to ask him, "Doctor, can you show me where in your records it indicates you took a detailed, thorough history?" And he doesn't have anything there. Would you agree that failing to take a detailed history is a violation from the basic standards of medical care? He has to say yes. If he doesn't, we can argue left and right. The problem is he's already admitted, he's already told the jury that it's appropriate in good medical care to take a detailed history. And if he has nothing there and he hasn't recorded it, that's a violation from the standard of care. And so I will continue going through that line of questioning throughout the course of cross-examination to establish that the doctor did in fact commit medical malpractice. Not coming right out and say, "Doctor, did you commit medical malpractice on my client?" That's not the way to do it. So why do I share this quick information with you? I share it with you just to give you an insight and an understanding into what goes on in these medical malpractice cases here in New York. You know, I recognize you're watching this video because you have questions or concerns about your own matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit, but haven't done so yet because you still have questions that need answers, what I invite you to do is pick up the phone and call me. I can answer your questions. You know, this is something I do every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.